Well, good morning, everybody. Thank you for joining Oliver and me this morning for a discussion on notification clauses or time limit clauses, and as they are otherwise known. We're scheduled to speak for about 40 minutes. It may be that we don't detain you quite that long, and we anticipate that there will be some time to answer questions at the end. So please feel free to use the chat function and we'll respond to questions then. If we run out of time, then by all means, feel free to send any questions through by email to myself or Oliver. So a rough plan for this morning. We are going to deal with the nature of these clauses, the possible pitfalls for an unwary claimant, and I'll run through some points arising from the case I dealt with in the TCC Triumph and Primus. And then we'll briefly discuss some drafting tips arising from the lessons learned from case law. So, without further ado, the nature of these clauses. Contracts often contain provisions prescribing the time limits within which claims must be notified to the other party under the contract. Lewison, on the interpretation of contracts, describes them as being in the nature of private contractual statutes of limitation. Case law has considered the purpose of these clauses, and it's fairly settled now that it is to enable the recipient of a claim to investigate and verify the disputes soon after the events which give rise to the claim, and having regard to the formulation of the claim and the factual material supporting it. So put a bit more shortly, the purpose is to give commercial certainty to the parties so that they can know where they stand and act accordingly. And that's going to include investigating the allegations and making any necessary financial provision for dealing with those claims and the litigation. We're over to Oliver to look at the judicial interpretation.
So in terms of the judicial interpretation of time bar clauses, the general approach of the courts has been to give the clauses a relatively strict construction. The reason being that, as was acknowledged in the Atlantic shipping case long ago, the effect of a contractual time bar clause is effectively a species of exclusion or limitation clause, and therefore such a clause is to be interpreted on the basis that parties don't intend to give up valuable rights easily. And therefore, notwithstanding that, of course, there are no longer any special rules applicable to exclusion clauses in the sense that the construction of any clause is always a matter of the language, purpose, contextual background, placing the contracts, etc. Generally speaking, in the event of doubt, ambiguities are in practice resolved contra proferentum. We'll come on in a moment to look at the approach the courts have taken to different types of wording, because they do affect the level of particularity that needs to go into a notice. But I think a key takeaway is that there's no strained construction applied to these clauses. It's one thing to say that they'll be construed strictly, but it's not the same. That doesn't mean they'll be strained. And in terms of what's been said in the recent cases, you've got the Drax-Smart case and the Dodica case. There's also the Noberhaar case from 2016, which is to similar effect. The point is that, yes, as Helen acknowledged at the start, the purpose of these clauses generally is to allow parties to investigate the circumstances of a claim. But equally, as was said in the Drax case, the courts are not seeking to create a minefield for a potential claimant by imposing unduly onerous standards upon a claimant. Well, of course, they've underlined that ultimately the issue is one of the particular words in any case.
So the usual components of a time limit clause or a notification clause. The first thing to say is that no two contracts will be the same. And the theme of this talk is going to be that each contract will turn on its own wording and each case will turn on its own facts. But there are some usual features, a combination of which tend to appear in contracts containing these clauses. The first one, as it says on the tin, will be to stipulate the notice period itself. What that notice period is a matter between the parties. It will no doubt be negotiated by a reference to the commercial reality of the situation in question, and in particular to whether the passage of time is going to substantially prejudice the proposed defendant's ability to respond because of the loss of evidence. But plainly, there's a real tension between the parties to the contracts as to what that period will be, and it might be expressed in years, months, or even days. The next matter is how to give notice and to whom. Invariably, it will be a requirement that notice is given in written form, but how should it be sent? Will it be recorded delivery, personal service, first class post, or electronically? And who should notice be sent to? It's not uncommon for a contract to say that it must be to a number of named individuals. That may include legal representative, not just members of the organisation. And generally, the purpose of that stipulation will be from the proposed defendant's point of view, to ensure that any formal notice served comes to the attention of somebody suitably senior, and will do so promptly. But as I'll come to shortly, care needs to be taken to follow the prescribed term to the letter, because there can be quite dire consequences if something that simple goes wrong. Most of the case law, which Oliver's going to address you on, centres around the content of the notice. The clause in the contract will set out what needs to be identified, and care needs to be taken in considering what the particular contract in question says. Often it will be a requirement to set out what the legal basis for the claim is. Usually it will be a requirement that the specific clause is identified, and though that's not always fatal. What's the factual basis of the claim? So why is it said that it's been breached? The degree of particularity required comes down to the wording, and that's where most of the disputes in the case law arise from. And there might well be a requirement for some degree of supporting documentation to be provided with the notice. And finally, quantification. Often clauses require an estimate of the likely value of the claim, and it may be that they also require how that estimate has been arrived at. Failure to comply with those terms can be a knockout blow to what might otherwise be a hugely valuable claim. So care needs to be taken. So first of all, it goes without saying, time bar clause 101, give notice in time. On the slide, I've quoted Lord Nichols, and Valentine's Properties was a Privy Council case in New Zealand, and it concerned a 5-day contractual time bar in a commercial property case. And after acknowledging the harshness of the result, Lord Nichols said at paragraph 20 of the judgment, and inherent in a time limit is the notion that the parties are drawing a line. Once the line is crossed, a miss is as good as a mile. And he went on in the judgment to say that the rigour of the principle is softened when the parties are taken to have intended otherwise. And he gave the example of the date for completion of a contract for the sale of land, where law assumes that time isn't of the essence. But he said, in relation to this case, the law makes no such assumption regarding a date fixed by a conditional contract as the date by which the condition is to be fulfilled. In the absence of contrary indication, the date so fixed must be strictly adhered to, and the time allowed is not to be extended by reference to equitable principles. It's extremely important, therefore, to know when time is up. It's easy to say behind the safety of a PowerPoint presentation, don't leave it to the last minute, but we all know that reality doesn't always allow the luxury of time and early service. consider then, how is time to be calculated in accordance with the contract? Is it expressed as within however many days, weeks, months? Is it after, or is it expressed as an anniversary? And a failure to properly analyse these expressions could result, worst case scenario, in a valuable claim being forfeited by a matter of hours. The next case to draw your attention to is the Zio Group International and Ainger case. There, the SPA contained notification provisions requiring that any claims against the defendants be notified to them within 18 months of the share purchase agreement. And it required service of a notice on each of the management vendors, they were called, and there were 7 of them in total. There was no issue between the parties that Zio managed to serve 6 of the defendants by the relevant date, but they did so on the very last date for service. The defendants applied for strikeout or summary judgment, alleging, amongst other things, and this case is worth a read, amongst other things, that the failure to serve one of those management vendors meant that no defendant was liable for the claims. The undisputed evidence was that a motorcycle courier had attended at, it was D5, attended at her address for service that was specified in the share purchase agreement. When he got there, he was told that she had moved. She no longer lived at that address and she'd moved to New Zealand. The courier left the house and he took the notice with him. Time for service from the terms of the SBA expired at 5 o'clock that day. He returned at 10 to 8 that evening and left a copy of the notice at the specified address, although the parties agreed that that was irrelevant. It was either served in time or it wasn't. It was also irrelevant that D5 had quickly become aware of the notice of the claim. She'd confirmed that in email to say she knows what the notice is about because she'd been told by her former colleagues. And the question for the court was whether there was notice complying with the terms of the SBA. And the relevant clause provided that notice would be deemed to have been received in the circumstances set out, including hand delivery to the address set out in the SBA. So what was required was delivery to that address, not to the individual named. And it didn't matter that service at that address would have been futile. And indeed, that's not unusual. There are plenty of instances in other areas of the law where service is valid, even if notice doesn't come to the attention of the other party. It's a common theme in landlord and tenant cases. It's also, if you take a step back, quite central to the way that CPR Part 6 works, with service at the last name address. So follow the letter of the SBA. The language of this particular contract in Zio left no room for implication, either that there should be a reasonable attempt at service or requiring the prospective recipient of the notice to notify of any change of address. So it followed that service on her was not effective. And on the plain wording of the SPA in this case, it was clear that failure to serve one meant that none of the defendants had been validly served the notice. And on that basis, as a matter of construction of the contract, what had been pleaded as a multi-million-pound claim was dismissed summarily. I'll hand over to Oliver now to discuss some of the pitfalls relating to particularity of the notice itself.
So I've dealt with the issue of the matter of the actual giving of the notice. And now we're turning to the question of what actually has to go in. And for the reasons identified at the outset, the focus is very much on the form of wording in the clause. There are, however, 2 general considerations that apply, whatever the form of wording. The first is that it's imperative when you're drafting one of these notices that you identify the warranties breached by the factual matters which are alleged in the notice. It's been said in the unreported cases, TOCO UK, although there are other authorities, uh, that if you fail to identify the warranties breach, that will almost always invalidate a notice. Because if you don't spell out the contractual breach as an absolute bare minimum, how is the other party to understand what the nature of the claim is? How is it to have any detail of the claim if it's just an incoherent set of facts? I say it will almost always invalidate a claim under a notice provision, because there is the decision of RWE, Newcomb and AEA, where the court took a very indulgent view of the particular notice in that case. And what was said in effect was that there were a series of very specific complaints about the account. And when one read the notice as a whole, it was possible to discern from the factual matters that were set out of it, in it specifically what claim was being brought under which warranties, even though the notice didn't set out in terms precisely the warranties that had been breached by stating we have a claim pursuant to clause X. That, however, is a very indulgent decision, and it's an absolute golden rule that you must in all cases identify the warranties breached. The other point to note is that the notice must always say, barring a very unusual form of wording in the notification provision, that a claim is in fact being made. Now, that may seem like a very obvious point, but again, in the laminates acquisition case referred to on the slide, you had a situation where extremely detailed particulars of the potential claim were provided. There was a third-party claim, the identity of the parties, the nature of the liability, the factual matters giving rise to the liability. They were all set out in the notice, and it was clearly possible for a recipient of it to understand what the claim would entail. The recipient would have been able probably to investigate the circumstances and form a view as to whether there had been a breach, what the extent of the liability was, and so on and so forth. However, the final sentence did not say that a claim was being made. It said something to the effect that this is to put you on notice of a potential claim that may be made under the provision, and the notice was deemed to be invalid simply because it didn't state that a claim was being made. This is, of course, a very easy trap to fall into, because in a typical SPA dispute, either you will have some issue arising out of the accounts where the value of the company has been overstated, or there will be some claim from a third party, whether that's a tax claim or whether it is some liability which has not been provided for in the accounts. And where you get a claim from a third party, it may very well be that the claim by the third party is disputed, or the quantum of that claim is unclear, perhaps because the third party themselves hasn't set that out clearly in the notice to the purchasers. However, in those circumstances, it's imperative that you put wording in the notice that says a claim is being made. If it's not possible to quantify it, you'll just have to say, we can't quantify it because the third party hasn't quantified it. There doesn't have to be an admission of liability in the notice in respect of the third party claim, but you will ultimately have to say, if the clause requires it, that there has been a breach, if that's what the wording requires. If it simply requires you to give notice of a claim, it will have to say this is a claim, even though the value of the claim may be zero or something to that effect. Everything turns on the wording of the particular clause, but in all circumstances, if it says you must give notice of a claim, it must be a notice of a claim and not a potential one. Moving over the page, in terms of the level of particularity that you have to give in relation to the nature of the claim or the details of the claim, while everything turns on the particular wording, it's clear from the case law that there's a broad distinction between provisions that require you to give details of the claim or details of the circumstances giving rise to the claim, or some variation on that form of wording, and provisions which either require you to give notice of the nature of the claim, or indeed only mere notice of the claim. And in relation to the first category, while it's clear that you don't have to give the same level of particularity as you would, for example, in a set of particulars of claim for legal proceedings, the reality is that there must be an articulation of sufficient facts that would allow the recipient to investigate the potential liability and form a view as to whether it's liable, whether it should pay upon the claim, what further steps need to be taken, etc., etc. That flows from the cases cited on this slide, and indeed the Drax and Dodica cases I referred to earlier. These clauses are interpreted by reference to the purpose of the provisions, and where it says that details of the claim have to be provided, they have to be details which enable those purposes to be pursued. Nonetheless, that does raise a question as to how much particularity is enough. And the reality is that there's always a measure of, with any vague legal standard, there is always a measure of risk. And the golden rule, irrespective of the wording of the clauses, if you are able to put particulars down on paper, you're sure those particulars are correct. Because, of course, there's always a risk when you draft a notice like this that you may be committing yourself to you may, if you're unsure, be committing yourself to a factual position from which it might be difficult to resolve later. But to the extent that there are facts of which you are sure, which form the basis of the claim, if those facts are available, there's simply no reason not to spell those out. There's no reason not to spell out what you say are the legal consequences by reference to the warranties. To the extent you're able to put a case forward on causation, there's no reason why you can't spell that out. And equally, when it comes to quantum, there's no reason why, in fact, there's every reason why you must spell out, without necessarily having to get into every pound, shilling and pence of the claim, there's every reason why you ought to set out the conceptual basis of the claim on quantum. However, where you have a provision which merely provides for the nature of the claim to be set out, as was the case in the matter of MDW Holdings and Norville, it has been said that a clause requiring the nature of a claim to be set out does not require the same level of particularity as the clause which requires details of a claim to be set out. And it might, although it would be extremely unwise to withhold particulars where they're available, if you are in a typical scenario in a post-M&A dispute where there is the last instalment of the deferred consideration is due, and the purchasers are fishing around for the typical warranty claims that are brought to try and resist that. If it isn't possible to provide great particularity and a claim is being advanced which is, as is common in these situations, entirely tactical, it may be possible to put forward a claim where the mere nature is stated, i.e. there we have a claim in relation to provision, page X of the accounts where line item Y said X, that is not correct. That may well, for example, articulate the nature of the claim without providing details of it. And what the courts say in relation to that, and indeed what was said in MDW, is that ultimately the notice provisions allocate contractual risk. And yes, the purposes of these provisions is to enable investigations. But ultimately, if the clause only says details of the nature of the claim, the purchasers simply haven't contracted So the vendors simply haven't contracted for a clause which gives them that protection. I add in relation to this that full particulars may be more onerous than reasonable detail. And if you did have a provision that provided for full particulars, it might be wise to go to something close at least to the level of detail that you would do if you were putting together a full letter of claim, or indeed particulars of claim, if that is possible. Yes, I've indicated the golden rule is to provide as much particularity as possible. The other point, though, before we move on, is, of course, that where you do have a warranty claim, yes, of course, you're trying to give as much particularity as possible. But, of course, in the typical scenario where warranty claims are raised at the very last minute, which may or may not be meritorious but haven't been fully investigated, you do have to be careful to draft the notice in such a way as to cast the net wide enough while the claim is still under investigation. So you provide what particulars you can, but in the usual way, there should be the usual reservations and qualifications, which spell out that if there are further circumstances which are under investigation, what those are, and some wording that it indicates that for the avoidance of doubt, to the extent that there are claims in that respect, they're caught by the claim that's being made. Because there won't be, in those circumstances, there won't be anything more that you can do in relation to that other than say that there are those further limbs of the claim. But you must be careful to cast that, having particularized those elements that can be properly particularized, just giving yourself, to the extent possible, on the known facts, sufficient leeway to say that the claim extends to the matters which you can't particularize. Just before we move on to the case study, there are issues that relate to quantification, because typically clauses will also require details of quantum to be set out. And typically there are two forms of wording which are commonly inserted in SPAs. Some clauses require only a good faith estimate of the losses on the basis of the facts known, or to the extent possible, or some variation on that. And in the Tioco case I referred to earlier, the court said that a good faith estimate is no more than an honest statement of the estimated value of the claim. It wasn't necessary for there to be any detailed breakdown of the estimate, and it wasn't indeed necessary for that estimate to be reasonable, as long as it was honest. In the Zayo case, however, the relevant provision provided that the estimate had to be reasonable, and that proved a real trap for the unwary there, because the way the claim was estimated was based as if the claim were an indemnity claim. Now, the claim that was advanced and which was kicked out was one that the value of the shares purchase was lower than it would have been if the warranties had been true, and that required one to compare the value of the shares in the situation where the warranties were true with the actual value of the shares on the date of purchase. Now, of course, while the value of the shares on the actual value of the shares on the date of purchase would, of course, be affected by claims by third parties, because, of course, if there are third party claims, the shares are going to be worth less. It's not true to say that the value claim is the same, would be the same in terms of its ultimate monetary amount as a claim under an indemnity in respect of third-party claims brought against the business. And it was on that basis in the Zayo case that the judge said, well, actually, it wasn't a reasonable estimate, because even if there might be some vague correlation between those two things, the wrong measure of damages has been used. The estimate is premised on a logical basis, which is wrong, and therefore it's simply incapable of being a reasonable estimate. So if a clause does require a reasonable estimate, that's something where you've got to be extremely cautious. And certainly if you're negotiating an SPA on behalf of purchasers, a provision requiring a reasonable estimate is one that you'd be looking in an ideal world to negotiate out and get down to a good faith estimate one.
So let's briefly discuss this case of Triumph and Primus. This is the case that I was instructed on regarding the sale of companies which manufactured parts for Boeing, Airbus and Rolls-Royce aeroplanes. It was a case I was led by Ed Pepperell KC on, as he was then, and it was heard over 5 weeks before Mrs. Justice A. Farrell and the TCC in London. But notice provisions were front and centre in this case. The share purchase agreement excluded liability for a claim unless within 18 months from completion, Triumph gave Primus notice in writing, summarising the nature of the claim as far as it was known to Primus and the amount claimed. Of note in this case is the fact that claim was defined in the SPA as a claim for breach of any of the warranties. There was a contractual cap of $15 million for liability for any claim for breach of warranties. And Triumph gave notice of claims made for breach of specified warranties. They stated the value to be far in excess of the $15 million cap, but limited it to the $15 million. When the claim was issued, it was to breach of the warranties that were contained in the notice, plus an additional warranty, warranty 7.2, regarding delivery and quality issues. Triumph then amended the claim to assert that Primus was in breach of a contractual requirement to serve a breach notice on them before completion, which would allow money to be deducted from the purchase price, or for Triumph to walk away from the transaction altogether. And their case was that they would decline the opportunity to walk away because the seller had failed to notify those breaches. And this increased the pleaded claim to a $64 million claim. A number of points were taken on the notice, but 2 are particularly worthy of comment. First, Primus argued that the entire notice was defective because it didn't include notice of a claim for breach of warranty 7.2, the quality and defects warranty. And you'll recall what Oliver said earlier about the golden rule being state what warranties you are relying upon. And that's precisely the argument that was run by Primus. But Justice A. Farrell rejected that argument in this case. And what she said was that notice had been given of other warranties, which included at the heart of them delivery issues to major customers. And she found that the contemporaneous documents that had been supplied with the notice indicated that many of the delivery issues were caused by quality issues. And the letter also identified breaches of 2 other warranties that were based on quality and delivery issues. And so she found at paragraph 117 of her judgment that reading the allegations and the other warranties together would notify the seller that complaints extended to quality and delivery issues. And she said, and I'll quote her here at paragraph 118, in any event, the fact that the quality issues were identified against some but not other warranties would not preclude pursuit of the claims, provided that the nature of the claims was sufficiently clear. In this case, the quality issues were fairly and clearly identified so as to give adequate notice that Primus was alleged to be in breach of its key customer contracts by reason of delivery and quality issues. So going back to what Oliver discussed earlier, best practice, recommended practice, is to identify each and every warranty that you are relying on in your notice. It may not be fatal, but it might be. There was significant litigation on it in this case. Provided, it may not be fatal, provided that there is sufficient detail in the notice. And again, that goes back to what Oliver said. If you know matters at the point when the notice is written, include them. Because even if you don't tick every box of every warranty that you're alleging a breach of, when read as a whole, you might get past that omission. In relation to this allegation that the seller was required to give a breach notice, the defendant asserted that Triumph had to give notice of that claim as well. That was resisted on the basis, as I've said, that the notice provisions of the SPA required only notice of the defined claims, and the defined claims were breach of warranty claims. That was rejected by Mrs. Justice A. Farrell, and she said at paragraph 127 of her judgment that the alleged breach under clause 6.6, the breach notice, is a breach of a different kind from the alleged underlying breach of warranty. However, it is dependent on and arises out of the alleged breaches of warranty. And she said the commercial purpose provided by the exclusion of liability would be defeated if Triumph were required to give notice of the initial breach, but not the failure to disclose that breach, which would have the effect of increasing the value of the claim by nearly $50 million. And she said that the intention of the parties must have been that a claim under the SPA would include any direct claim for breach of warranty, together with any claim arising out of a breach of warranty. And that properly construed, the buyer had to give notice of all claims in respect of any breach of warranty within 18 months of completion, including the claim for a breach notice. And the practical effect of that in this litigation was that the claim was limited to a maximum value of $15 million, and the claimants lost the opportunity to pursue that additional $50 million in the litigation. So a learning point to take from this is to consider carefully, not only giving notice of the breaches, but consider whether there is anything arising from the breaches themselves that you might also have to include in that notice. So that leaves us just with a couple of minutes to look at some drafting considerations. We've sort of talked about these as we've gone through, but inevitably there is a tension between a claimant and a defendant, or the parties to the contract when it's being drafted. And what we've done here is looked at what a prospective claimant might want to push for versus a prospective defendant. Oliver, is there anything in particular that you want to pull out that you've not already mentioned as you've gone through?
Yes, I think we've actually covered most of these points in here, save for the documentation point. From the perspective of the vendors of shares, one potentially useful mechanism for making claims difficult, and indeed one that may actually have some practical utility in assessing a claim, is to insert a requirement in the clause for the provision of, say, all reasonably available supporting documentation, or documentation known to be available. Just in relation to these clauses, if you're a prospective claimant, if you agree to a documentation requirement, you've got to be careful, because if it requires all documents relating to the claim to be disclosed, there may be an argument later that you couldn't adduce further evidence. So on any view, it would be an appropriate clause would be all reasonably available documentation. But that will help in the situation where you have a totally opportunistic claim, where there are threatened claims by third parties and it's all hopelessly vague, and so on and so forth. There may be issues with particularity in relation to such claims, but even if they get over the particularity hurdle, if there's no material to substantiate that claim, then you may be in a position where if that claim is advanced at the last minute in the typical deferred consideration scenario, then the material might be such as to, for example, enable a summary judgment application on any claim, or the seeking of declarations of non-liability or something. And in any event, to impose that sort of requirement just presents the possibility of at least a technical defence being raised if once a claim is actually brought, somewhere further down the line, further documents come out in disclosure and you say, well, you had this material anyway, it wasn't disclosed, or reasonably available supporting documentation wasn't there, and the what might otherwise be a meritorious claim might be killed later on. So that's a potentially useful provision for a vendor. But beyond that, obviously, we've covered all the other points. The greater level of particularity, the better from a defendant's point, less so from a prospective claimant. And obviously, prescriptive service requirements, that sort of thing. If you're a prospective defendant, put those in. If you're a prospective claimant, that may not be a huge issue, but you'd be surprised how often in practice parties don't comply, as in the Zayo case, particularly when you're getting to the last minute. But beyond that, I think we've pretty much covered the bases.
Yeah, thanks, Oliver. We've just got one question in the Q&A, which is, can the court decline jurisdiction if a party has failed without compelling reasons to comply with the provisions of a dispute resolution clause before commencing proceedings? That's a whole talk in and of itself.
But that's a whole talk in and of itself. I mean, the short point is it depends on the dispute board provision. If there is a prescriptive mechanism with inadequate provision for time frame, and it's clear what has to be done and by whom, then yes, you have to comply. If it's the sort of provision that says the party shall engage in good faith negotiations, then it's not sufficiently certain to be enforceable. That's the broad approach to matters, but I don't think we can say much more beyond that.
No. That takes us to time. And thank you, everybody, for joining us. If there are any other matters that arise that you want to follow up with us afterwards, feel free to get in touch by email. And thank you for listening.